Okay, my name is Nadarajah. I'm a lawyer with the Canadian Environmental Law Association. And what I propose to do, Rick, I promise, in 5 minutes, is to briefly outline the experience in both the US and Australia with anti-SLAPP legislation, and outline some of the key elements that have been incorporated in legislation to counteract SLAPPs. I'm going to focus primarily on the US because that's the jurisdiction which has taken the lead in addressing this issue. In the United States, 27 states and 1 territory have passed anti-SLAPP legislation with varying degrees of protection. And one of the key challenges in drafting anti-SLAPP protection is determining how far is it necessary to go in order to protect public participation. And there are 2 law professors at the University of Denver, George Pring and Penelope Canaan, who have reviewed the various legislation that have passed in the states and have assessed their effectiveness. Incidentally, Pring and Canaan were also the 2 professors who coined the term SLAPPs, and they have done the most extensive research on this issue in the United States. Pring and Canaan identified 3 evaluative criteria for assessing the effectiveness of SLAPP legislation. First of all, the communication has to cover all forms of public advocacy and communications to the government, whether direct or indirect. So in the Ontario context, this would cover all comments made under the Environmental Bill of Rights. It would cover all presentations made to municipal planning meetings. It would cover all such things as letters and correspondence to government, boycotts, as well as demonstrations. Secondly, in terms of the forum, it has to cover all arms and levels of government. And finally, the legislation should focus on both prevention and cure. So to be truly effective, anti-SLAPP legislation has to provide for a mechanism for early review by the courts. It has to shift the burden of proof to the SLAPP filer to prove that the communication is in fact not protected, and provide for a means for deterring others from filing these kind of suits in the future. And using these 3 evaluated criteria, they identified Minnesota's anti-SLAPP law as being probably the most effective. And what Minnesota does, its anti-SLAPP laws, essentially immunizes all lawful conduct or speech which is genuinely aimed in whole or in part at procuring government action from liability. So what Minnesota's law essentially does is it requires the trial court to dismiss an action unless the SLAPP filer can provide clear and convincing evidence that the acts of the target are not immunized. So in other words, in a motion for dismissal, the only issue is whether the filer can prove that the actions which are the subject of the litigation are not aimed at procuring government action. Now, in contrast, in other jurisdictions such as Australia, anti-SLAPP legislation is in fact considerably weaker. In Australia's anti-SLAPP law, in fact, states that it categorically states that it's not going to protect defamation actions, that it doesn't apply to it. Similarly, in Canada, as Hugh and Norman will discuss, in BC, which passed anti-SLAPP law legislation and it was subsequently repealed, and as well as Quebec, where Norman indicated it was being proposed, we have not seen the kind of broad immunity provisions that are provided by the U.S. states. And that, in my view, is really unfortunate, because the legal commentators who have looked at this issue in the United States have said that there is a tendency on the part of trial judges to resist early dismissal of SLAPPs unless the legislature is very specific in terms of its intent to protect public participation. So my final point is that obviously we will have to craft a Canadian response to this problem, but to that end I think that the various anti-SLAPP legislation that have been passed in the U.S., as well as the substantial SLAPP jurisprudence that is developed there, I think can help fashion a Canadian response in terms of addressing this growing phenomena.